I'm shorter today. This is the worst day. You guys have forgotten my heels because you're about to meet two of my very tall co-workers. You've already met one of them, and so this is not the day to compromise my authority. But again, thank you for joining. We're very lucky today because we have two guest lecturers with us. Both Colin and Elizabeth are colleagues of mine at CPSA. And so Colin is I manage the intake and preliminary investigation. We have another manager for investigations. That's what Clay did. You guys met him not too long ago. And then Colin manages the hearing. So when a physician will actually go in front of a hearing tribunal similar to a trial, he does all of the coordinating for that. And Elizabeth does the prosecuting for that. So she's actually the lawyer that will stand up and make our arguments and examine witnesses and do all of the lawyering kind of stuff that we see on TV.
Hey everybody. Wow, a lot of faces. A little bit nervous. Last time I had to talk in front of this many people, all I had to say was not guilty. So this is a nice change of pace. So I'm going to, like Dima was mentioning, I'm a lawyer by trade. I went to the U of A, grew up in a small town just outside of Edmonton. Was in private practice for a number of years, mostly doing family and divorce law, and then pivoted into professional, negligence defense claims handling for other lawyers before coming to CPSA and managing the professional conduct department's hearing tribunal process. So today what I'm going to do is talk about a couple of different causes of action, or in simple terms, things that you can sue other people for when they happen. The first one is occupier's liability, then we're going to go into nuisance a bit, and then what's called the rule in Rylands and Fletcher. If you have any questions at any point in time, just put up your hand too, or you can shout them out, whatever is easier. Occupier's liability. So the Occupiers Liability Act in Alberta sets out the legal duties for people or organizations who are called occupiers of premises or who occupy a particular plot of land or space. It also governs responsibility and allocates, responsibility for damages that can result or that do result from injuries that you might sustain when on somebody else's premises. So I guess the first question is, who are we talking about when we're talking about occupiers? So Section 1C of the Occupiers Liability Act defines occupier, or the person or entity that's responsible for upkeeping the premises, as somebody who has physical possession of the premises, such as if you're a tenant and you're renting a place, you're renting an apartment, you're responsible for the space that you're leasing, as long as you're possessing it. Or if you have responsibility and control over the condition of the premises, the activities that are conducted there, and the people that are allowed to be on the premises. So this can expand it to not just landlords and tenants, but also things like event organizers. So if you were putting on a concert, for example, and you're determining who can come in and come out, you're responsible for ensuring that there's appropriate safety precautions in place and procedures and things like that. So the term occupier is defined fairly broadly, and importantly, there can be more than one occupier at the same time. So let's say that I'm at Elizabeth's house and I get hurt, and Elizabeth is also renting it from Dima, who lives there too, and they share a 2-bedroom. Then I can potentially sue both Elizabeth and Dima, as they're both occupiers of the same premises. So who do these occupiers owe this duty to? So the Act under Section 5 says that it's every visitor. So an occupier, in this respects, every visitor, so everybody who's allowed by law or invited to be there with permission. Occupiers are required to take such care in all of the circumstances of each case that's reasonable to see that the visitor will be reasonably safe in using the premises for the purpose for which the visitor is there. So in other words, you need to take reasonable steps to ensure that your visitor, the condition of the premises, the activities conducted on it, and other things, the circumstances are reasonably safe for the person that you're having there. which isn't a standard of perfection. And we'll kind of get back to that in a second. But again, for the purpose that they're invited to be there. So you could see how this might apply differently if you hired a contractor to come and do some work in a bathroom or something like that, versus a friend coming over on a Friday night, or if you were having a young cousin or niece or nephew or something like that come over as well. So each, again, situation is very specific. Any questions so far about who occupiers are, or what, I guess, duty occupiers owe to people who come onto their premises or onto their land? None?
You're doing such a great job explaining it, Colin. There are no questions.
We talked about people who are permitted by law, like, for example, a police officer, or somebody implicitly, like somebody who, again, might be a contractor or a friend or cousin or family that you invited over. But what do you think happens when we've got somebody who's not allowed to be there? So a trespasser, for example. Do you think that there's any, I guess, duty owed to somebody who comes into your property or onto your premises without your consent? The answer is not really, but kind of. So a trespasser under the Occupiers Liability Act is somebody who, I guess, isn't permitted in law or doesn't have consent to be on the premises from the occupier, or somebody who's initially allowed to be there but subsequently is directed to leave, or whose permission is, I guess, revoked partway through their I guess, inhabitants of that area. So again, it also applies to, for example, party guests who you might have over that you actually ask to kind of get out after they've drank too much or something like that.
So let me ask a question based on what Colin just said. If somebody is visiting my house for dinner, do I owe them more or less of a duty of care than a trespasser? And why is that? I consented to them being there, absolutely. And what else do we know about occupiers' liability? Exactly. Yeah. So what's said there in more or less words is you have to come to the court with clean hands. So you can't commit a crime or do something wrongfully and then come and sue somebody about it. Obviously, as we know from previous chapters, there's criminal trespassing and there is the tort of trespass, and the seriousness would be adjusted accordingly. So if somebody's trespassing to rob you and then, breaks cuts their arm on the window that they broke to get into your house, not really owing them the same duty of care as somebody coming into the front door if the window is broken and they cut themselves, right? Good understanding. Good job, Colin. They're following.
And so to caveat that as well, although you might not owe the same duty of care to trespassers or people that aren't permitted or invited there to be there by law, you can't intentionally go out and injure them either. So the Occupiers Liability Act can find you liable for the injuries of a trespasser if the damage or the injury that they sustain is a result of your willful or reckless behavior. So for example, I can't go around putting bear traps on my front lawn, or one of those guillotine things that kind of cuts off your hand if you're trying to break around the window and unlock the door or something like that. So in those kind of situations, there's a possibility that you could be fined liable. So it protects you, I guess, against trespassers, except from willful or reckless conduct. So, and that kind of is what Dima was mentioning is in contrast to a situation where, for example, the walkway from the side of the house back to the garage that's in a fenced-off area, if there's ice along that in the winter, somebody trespasses, they slip and fall, crack their head or break their arm or something like that. Probably not foreseeable that, I would expect anybody to be there in the middle of the night, and probably not reasonable for me to take any steps to safeguard against a trespasser going on there and hurting themselves. So that'd probably be a situation where there's really no, I guess, liability for me under the Act. But the long and short is you can't go around intentionally or recklessly trying to harm somebody, in which case you can be found liable for their injuries. How about for kids? Anybody have any thoughts? How about for kids that are trespassing? Should the principle be different if, somebody's 14, for example, versus 44 and they're trespassing? Any thoughts? Yeah, a couple head nods. Well, that's what the law thinks too. So for children, the Occupiers Liability Act does treat things a little bit differently. So under Section 13, if an occupier knows or they have reason to know that a trespasser is on the premises and that the condition of the premises or the activities conducted there create a danger of death or serious bodily injury or harm to the child, then the occupier owes a duty to the child to take such care as reasonable to see that in the circumstances the child will be safe from that danger. So there's a high threshold that you have to, meet. So the risk of, injury has to be serious. It has to be serious bodily injury or death. In which case, in that circumstance, you do still owe that duty under the Act to children trespassers. So it does apply differently depending on whether you're a minor or an adult. And there's no, bright line rule for how do you determine whether something is reasonable, and that really depends on the circumstance of each scenario, you could say. But for children, there's a couple of things that the law looks at in determining whether this occupier who had a child trespasser on their property that got hurt took reasonable steps to ensure that they were safe during their time there. And those steps are the constellation, of factors that the law looks at in determining that are how old is the child? The older they are, the probably more prudence and practicality they should have about navigating the circumstances. The law also looks at a child's ability to appreciate the potential danger and risks of being there and any activities that are going on. And it also looks at the burden on the occupier of eliminating the danger, protecting the child from harm, compared to the risk that circumstance presents to the child. So a bit of an inconvenience test versus, the balance of risk of harm versus what the law might reasonably expect of an occupier who probably doesn't want children trespassers running around their backyard, kind of thing. So in summary, Occupiers Liability Act provides a statutory or a legislative cause of action that people who possess or control premises have to live up to, and provides for a duty of general care to people who go to their places, with certain exceptions carved out for trespassers and child trespassers. Any questions on that? Okay, perfect. So the next, type of lawsuit we'll be looking at is in cause of action of nuisance. So nuisance is a common law tort. So it's a judge-made law that it aims to protect somebody's use in their enjoyment of land. And this isn't, as much about a trespass in the traditional sense, if we think it, something or somebody migrating or, physically going from one location onto another. But it's meant to, address an interference. So a nuisance essentially occurs, as it mentions here, when somebody's activities on their own land unreasonably interferes with another person's use and enjoyment of their land. This nuisance has to be, beyond a minimal threshold, so it has to be substantial and unreasonable. And to be able to prove nuisance, the person whose land is being unreasonably interfered with has to show that they have a possessory interest in the land, so they have a right to occupy or be there. And that the defendant's action, so the person doing whatever the issue is causing the interference, and that interference is both substantial and unreasonable. So how do we know whether what somebody's doing is unreasonable or not? Again, it's a contextual analysis, but some of the things that a court looks at, again, that have developed over time as the law has developed, is the nature of the neighborhood, the time the time in the day, intensity and duration, social utility, and motivation. So I guess just to illustrate, the time in the day, for example, if I was having pallet fires in the backyard in a residential neighborhood in Stony Plain, for example, maybe once a month on a Friday, that might factor into whether that was reasonable or more reasonable than a situation where I'm doing that 24/7 in that same neighborhood around the clock. So again, it's a reasonableness analysis to determine whether or not the action that's being complained of is in fact problematic to the level that it rises to a nuisance. So typical examples in real life we see are excessive noise, so from construction sites sometime, for example, foul odors, pollution or smoke, machinery vibrations, flooding or water diversion, or persistent light or dust. So again, let's say that my neighbor has parties until 5 a.m. every single night of the week. And there's loud music, they're blasting 21 Savage or somebody else all night, same song. That might be something that is probably unreasonable after a prolonged period of time. A backyard fire pit, again, another example with the smoke constituting the nuisance or potential nuisance in that scenario. If you live by a gravel pit, for example, that was recently constructed, and there's dust from all the trucks driving by 24/7, and that dust is interfering with the adjacent land, so your neighboring properties' use and enjoyment of the land too. That can constitute a nuisance potentially. So can, for example, let's say that you lived right next to a storage facility that had these bright flood security lights shining in your window every night 24/7. So again, it's not about a trespass here. It's about a unreasonable interference with your use and enjoyment of your property. Is there any questions on that? Go ahead.
What if the construction was conducted by the city? Could the person, like, let's say the construction itself is really loud for a long period of time, and sometimes they even continue into the night, can the person sue the city for that, as nuisance?
Good question. That brings us to the next slide. I'm going to park that for 1 second and then get back to it. Yeah, on the defenses. So there is a defense to nuisance that says I was authorized in law to perform this activity, and I am doing exactly what I was authorized to do. In that kind of a scenario, that can be one of the defenses to it, saying that, for example, yes, I do acknowledge that this noise, for example, is ridiculous, and I appreciate it's keeping up and everybody up at night. But that being said, I was specifically legally authorized by the city to perform this construction work during this time for this amount of time. In that case, you can sue everybody for anything, but it would probably have a decent defense there. That being said, one of the things that would also come out too is how closely were you complying with what you were legally able to do. So for example, would there be another way that you could have done the same thing that you were legally or allowed to do in a little bit less intrusive way? And then if that's the case, then that could potentially reopen that conversation. Does that answer the question?
I'm just going to put one more question to the class. Looking at this slide, can anybody think of any other reasons that construction might not qualify as a nuisance?
Social utility.
Social utility, expand on that.
I need social services in terms of construction. I need my road to be roading properly. I need my street lights to be street lighting properly, that kind of stuff.
It said in true Gen Z fashion. On our way here, Colin asked me if I used slang. So that's their best example today. Did you have something?
It was kind of more just along the lines of for the greater good.
You are all correct. That is all exactly right. So when we're looking at all of those factors, we're looking at motivation, we're looking at social utility, among other things. Construction is necessary for society. Construction is also loud. Also, as we learned in chapter 2, lawsuits take a lot of time and are expensive. So if there's some construction going on outside of your house, it's really gotta be a nuisance for it to be worth going to court and for you to be successful in a time that it would even be worthwhile. That's my 2 cents based on it.
And for specific industries as well, like agriculture, for example, and construction, there's a whole other subset of regulations and things like that that apply that narrow. But these are just some, I guess, general principles of this, I guess, cause of action or reason or cause that you can sue for, if that makes sense. So all of those things are looked at in determining whether an interference is reasonable or not.
Just to point out, the timing is not important. That's a very easy exam question for me. So if your previous neighbors had no problems with your parties every day, it doesn't make it any less of a nuisance that I have a problem with it. And so being there first doesn't matter in this scenario. Ready for Ryland?
I think that's it. Any other questions on nuisance before? Yeah, go ahead.
What's like some of the examples, like specifically like the neighbors or the party or smoke or whatever? If it's like a one-time thing, could you still, if you were that upset about it, could you still, I guess, look for nuisance, or would it have to be like an everyday?
One-off thing, looking at those factors again, time and date, intensity and duration, right? If it's something that's very episodic or short or, every now and then, probably not as concerning or not as easy to prove as something that's prolonged, a little bit more obnoxious in your face, that really, I guess, on a daily basis or periodically really disturbs your ability to use and enjoy your property. So, I mean, would you be able to prove it? Probably not in that scenario. The last cause of action I'm going to talk to you guys here today about is the rule in Rylands and Fletcher. So this was a really interesting decision if you're a nerd like us, from 1868, which is before even the three of us were born. It's an old English decision from the House of Lords that was really a landmark case of tort law that established the doctrine of strict liability for dangerous things that you're bringing onto your property.
Wait, let's just pause there. Who remembers what strict liability is? Oh,
Well, you can do this all. It's like if it's an extraordinary activity, you're just liable for whatever happens.
exactly. So you're doing something so risky, you're automatically liable.
So Fletcher owned a piece of land over here. And Fletcher was thinking, okay, you know what? I'm going to build a reservoir on my property. So Rylands did, and they created this reservoir on their land over on the boundary on their side. During construction, it was sort of discovered that there were these old abandoned mine shafts that had been closed up but not necessarily properly sealed. And after, what ended up happening is that the reservoir ended up leaking water into the mine shaft, flooding it, and then causing a bunch of damage to their neighbor Fletcher's mine. So essentially, the construction was fine. There wasn't any negligence or anything like that. Nothing was done improperly. But Ryland still sued Fletcher. So it broke, the water broke the old shafts, flooded the mine, and then there was significant damage to Fletcher's mining operations. The issue that the court was trying to decide in that case is that, well, we don't have negligence here. We don't have any intentional tort or any intentional harm or injury or wrong being committed. Can Rylands be held liable for the flooding even though they weren't negligent or didn't engage in really any untoward conduct? So the defendant, Fletcher, was held liable, strictly liable, for a non-natural, what the court called a non-natural use of land, if it escaped from their property and because it escaped from the property and injured the plaintiff, mine owner in that case. So the rule essentially from that, which still, I guess, to this day is adopted in many jurisdictions and modified somewhat, is that a person who, for his own purposes, brings on their land and collects and keeps there anything likely to do mischief if it escapes, must keep it at his peril. If he does not, he's prima facie answerable for all damage, which is the natural consequence of its escape. So, in other words, if you bring something potentially dangerous onto your land, like chemicals, for example, something that creates a special or unusual danger, and it escapes and causes harm, then you're liable, even if you weren't negligent or intended to cause any harm, even if you weren't reckless. The fact that you have it, if it gets out, too bad, your fault. And this has to arise from a non-natural use of land as well. So like in this constructing a reservoir, for example, what we see, I guess, examples of would be, and there's a whole subset of rules and regulations around this as well, but chemical storage, this is often illustrative of a lot of times when like mines or processing plants are leaking chemicals or even radiated water into the ground that contaminate the soil and those sorts of things. Doesn't matter whether there were precautions in place, anything like that. The fact that it got out means that you could be liable for it. So that's essentially the rule in Rylands and Fletcher, which is, I guess, another cause of action or something you can be held liable for in relation to the use of land. So any questions about that particular, I guess, potential lawsuit or cause of action? So just be careful with what you have on your property, I guess, is the answer to that. So between the occupier's liability, negligence, and then the rule in Rylands and Fletcher, if nobody has any questions or anything like that, that's all I've got here for you, and I'll pass the clicker here to Elizabeth. Oh, thanks.